All right, let's talk about diminution of value versus reasonable cost. So far, we've discussed that expectation damages is the measure of how much the injured party would have received under the contract, how much the party would have received if the contract were performed. Expectation damages are designed to give the party the benefit of the bargain. But sometimes it's hard to tell the value a party would have received if the contract were performed. The future is always uncertain. So how can the law measure what a person would have received if things turned out differently? Even in the simple case of Frances, how did we really know that it was worth exactly $11,000 to her? Let me give you an example. Imagine a land developer hires a contractor to build a house on a piece of land. If the house is built properly, the house and the parcel will sell for $500,000. But the house is built badly, and it's only worth $400,000. And the defects could be fixed by another contractor for $90,000. So for a total of $90,000, the house would be worth $100,000 more. Should the contractor be liable to the land developer for $100,000, which is the diminution in market value because of the breach, or should the contractor be liable for $90,000, which is the cost of remedying the defect? See, here, the amount the value decreased because of the breach is different than the amount that would have to be paid in order to make it as if there was no breach. So what's the right measure of damages? Restatement section 348. Section 348 in the second restatement of contracts addresses this and says, if a breach results in defective or unfinished construction and the loss in value to the injured party is not proved with sufficient certainty, he may recover damages based on A, the diminution in the market price of the property caused by the breach. In this example, that was $100,000 because the house would have been worth $500,000 if it were built properly. It was built improperly and therefore worth $400,000. That's $100,000 diminution in value. Or B, the reasonable cost of completing performance or remedying the defect if that cost is not clearly disproportionate to the probable loss in value. In this case, that would be $90,000 because that's the cost it would take to fix the defects with the house and make it as good as it should have been if the contract were performed. What is the correct measure of damages? The parties get to choose. This rule allows the injured party to choose whether to get damages as measured by the diminution of value or the reasonable cost of cure. The party will generally take whatever is greater. There is a limitation to this. The party will generally choose the greater of the diminution in value or the reasonable cost of completing performance, whichever is greater, but the party cannot select the reasonable cost of completing performance if the cost of cure is unreasonably disproportionate. So our limitation there is reasonableness. This sounds simple in theory. It's not, unfortunately, so simple in practice. Take the famous case of Groves v. John Wunder Co. Groves sold the right to mine gravel from land that Wunder owned and would pay $105,000 and promised to restore the land to a level grade when he was done extracting gravel from it. But Wunder left the land ungraded, and Groves sued. What should Groves receive? This is a breach, right? The contract was not performed. The contract promised to return the land to a level grade. That didn't happen. That's a breach. So what are damages? Groves, of course, sought $60,000, which was the cost of cure. That was the amount it would take to fix the land, to cure the defect, to level it. But Wunder defended and said, this land is only worth $12,000 less because it's not level. This is some commercial or industrial land, and it being level is not that relevant to its value. So does Wunder have to pay $60,000 or $12,000? Well, the court answers that question in the following way. If Groves received $60,000 in cash, would he use that money to level the land? Well, would a rational person who has an investment property spend $60,000 to increase the value of that property by $12,000? No, a party would not do that. A rational party will not spend $60,000 to earn 12. That's a net profit of negative $48,000, a loss of $48,000. And so the court here does not agree that the damages should be the cost of cure, because here it is considered disproportionate to the change in the value, and so the party only receives $12,000, which is the difference between the value of the land as if it were graded versus the value of the land ungraded. Why does the court say that cost of performance, not diminution of value, is available? Well, sometimes we do need to factor in choice B, the cost of cure, because some promises are not really concerned with objective market value. In the case of Groves v. John Wunder Co., it was some industrial land. The only thing that mattered was its value. But some contracts are about subjective, personal value. To put it another way, there's no accounting for taste. Let me give you an example. Greg hires Helga to build a 30-foot tall mauve birdbath out of concrete in his backyard for $30,000. By all accounts, the hideous monstrosity will diminish the value of his property by $20,000. But Greg is a fan of such eyesores. He loves nothing more than seeing mauve, 30-foot tall concrete birdbaths in his driveway, although most people would not. If Helga breaches, should she receive $20,000 for not building this monstrosity? Well, that, of course, does not make sense. He contracted for something that would diminish the value. Her breaching actually increased the value of his land. Would we pay her $20,000 to not perform? No, of course that doesn't make sense. This was something subjective. What does Helga have to pay? She must pay for the cost of performance. Greg bargained for an ugly birdbath, not an increase in his land value, and so he shall receive an ugly birdbath or its financial equivalent. Again, the general rule of contract law is parties should receive what they bargained for. We don't assume that parties want one thing or another. We listen to what the parties actually bargained for. We assume parties seek to make themselves better off by contract, and we try not to second guess it. And so sometimes we have to apply the cost of cure, although the preferred method, especially in commercial circumstances, will be diminution in value. So we just spoke about whether to use diminution in value or providing damages that amount to how much to cure. Next we'll talk about lost volume damages. But first, any questions about diminution in value versus cost of performance?